Michael, I'll leave it over to you. We'll all be on the background. If anyone has any questions, feel free to use the chat options or reach out to us, but you guys can get cracking. Thank you very much, guys. Best of luck.
Thank you very much. All right, so again, let me just identify each of our panelists and give them an opportunity to say just a bit about themselves. I'm Michael Dell'Angelo. I'm a managing shareholder of Berger, Montague in Philadelphia. We're here moderating session 1, conditions for class certification, and we're excited to join you and kick off the sessions today. Again, we have Kimela Shah, senior consultant with Oxera, Gordon Cooney, a partner at Morgan Lewis, and Joseph Saveri, founder and CEO of Joseph Saveri Law Firm. So, would each of you like to just give a brief background of your practice, and then we can jump into the session? Start with you, Kimela.
Sure. Hello, I'm Kimela. I'm an economist at Oxera. I've worked on a number of class actions in the competition and consumer space in both the UK and Canada, both on the claimant side and the defendant side, and very excited to be here at this event.
Hello, everybody. My name is Gordon Cooney. I'm a partner with Morgan Lewis in the United States. I have the privilege of heading up our 500 lawyer litigation practice around the globe. My practice has focused on the defense of class actions now for, it's hard for me to believe, but 35 years. We've got a leading class action defense practice in the US, and we've been paying very close attention both in the US and around the globe to the developments that have been going on with respect to class actions, collective actions, and group litigation orders. And it's a pleasure to be here and be part of this distinguished panel.
So that leaves me. I'm Joseph Saveri. I'm from San Francisco. I founded my firm about 9 years ago. I've been doing antitrust work and class action work for going on 30 years now. Most of my practice is plaintiffs' contingent fee class action litigation with a particular focus on antitrust cases. We are lead counsel in a number of large cartel cases in the United States, including the capacitors case. We do direct and indirect purchaser cases. We also do a number of other types of cases, single firm, dominant position cases, no poaching cases, and some sports cases. So it's nice to be here. I'm in California, and so I should wish everybody a good morning from San Francisco. So nice to be with you.
Thanks to you again, and again, welcome to everybody, and thanks for joining us. We have a kind of an ambitious agenda for our panel today, so I'm going to jump in with a little introduction and get us started. So in 1966, with the enactment of the Federal Rule of Civil Procedure 23, the United States ushered in the era of class action litigation. A little over a decade later, provinces in Canada began to establish procedures for collective action, and other former British colonies, such as Australia, have adopted similar forms of the debate. And however, the adoption of class action litigation in the United States has been broad, the use of the procedural device extensive. Adoption elsewhere, including Canada, has been relatively limited. Indeed, many have viewed the UK and Europe historically as being particularly reluctant to embrace the very concept of collective actions. A collective action regime was finally implemented in the UK by the Consumer Rights Act of 2015, which amended the Competition Act of 1998, and that is as to competition law claims. And in a recent landmark judgment, Merrick's v. MasterCard, which we'll spend a bit of time on today, the UK Court of Appeals has paved the way for at least collective competition claims in the UK. Today, our distinguished panel will address the conditions for class certification in the US and the UK, with a particular focus on the impact of the Merrick decision. So let's just begin with a little background, very broadly, on what Rule 23, the US rule for certification, requires. I'll give you a very broad and high-level view so that we can use that to frame our discussion of merits. First, Rule 23 has several implicit requirements. There has to be a live claim or controversy. The class representative must be a member of the proposed class, and the class must be defined by objective criteria. This implicit mandate, referred to in some circuits in the U.S. as ascertainability, can also require that the plaintiff identify an administratively feasible method for determining who's in the class. Ascertainability is often a key point of contention in U.S. certification battles, and the analysis can vary very much by jurisdiction. Second, Rule 23 has a number of explicit requirements. Specifically, there are requirements under Rule 23A that apply to all classes, and requirements under the various subsections of Rule 23B that apply depending on the type of class that the plaintiff is seeking to certify. Under Rule 23A, the requirements that must be satisfied for all class members are, first, numerosity. Generally, a class is sufficiently numerous if it has more than 40 members. Commonality. Common questions must exist, and those questions must be susceptible to common answers. Third, typicality. Put simply, the claims of the class representative must be shared by the members of the class. And last, adequacy. The class representative must have no major conflicts of interest with absent class members, and counsel must have the requisite experience with the claims or class actions. Next, at least one subsection of Rule 23B must also be satisfied. And there are 4 separate subsections. 23B1A provides that a class can be certified if there's a risk of inconsistent rulings that would establish incompatible standards of conduct for the party opposing the class. These are cases such as those involving retirement benefits administered by certain private companies under the ERISA statute of the U.S. that would be brought on behalf of all members of the plan, where a determination about the defendant's conduct and its alleged violation would have a bearing on the defendant's future conduct with respect to all or likely all of the similarly situated individuals, such that they couldn't be treated differently based on the conduct going forward. 23B1B applies to cases with limited fund settlements, where the settlement funds available are less than the aggregate damages. A class could be certified to ensure that the funds are allocated appropriately. And in this instance, there's an optional notice procedure, and the class members are not permitted to opt out of the settlement. 23B2 covers class actions seeking declaratory or injunctive relief. Injunction-only classes have no notice requirement or opt-outs, and the rule requires only that the defendant acted or refused to act on grounds that are generally applicable to the class. And lastly, the subsection of Rule 23B that I think we see most frequently is 23B3, which applies to classes in which the class is seeking damages, that is, economic damages. And there, the named plaintiffs must establish 1, predominance, and 2, superiority. For the predominance requirement to be met, common issues must predominate over individual issues, and the predominance requirement is where many cases rise or fall, and the issues can get very complex, particularly in competition or antitrust litigation. The proponent of class certification must also show that the class action is superior to other means of litigating the case, focusing on factors like the class's interest in concentrating cases in one forum, the interest of class members in controlling their own litigation, problems with managing the class case, and the extent of other similar litigation. The Court of Appeals decision in Merits provides an initial in-depth look at how the UK will likely approach the analysis, which, by all accounts, is thus far less complex and searching under Rule 23. Our panel will explore the key differences, some of the apparent reasons for those differences, and what they mean for the practice. Let's begin with a brief summary of Merrick from the perspective of each of our panelists. Kimela, would you kick us off with an overview of Merrick's?
Sure. So I'm sure lots of people on the dialed in today are familiar with the case, but I'll give an overview. So the Merrick's case relates to a restriction of competition in interchange fees. Walter Merrick's brought a claim against MasterCard on behalf of all consumers in the UK. It's one of the largest damages claims in the UK, £14 billion opt-out consumer class action representing 46 million people over a course of 17 years. The claim is a follow-on action and argues that there was a very high pass-on of interchange fees by retailers to consumer prices, and as a result, prices of all goods and services in the UK rose, not just those purchased with MasterCard. It's appropriate to add a disclaimer here. We at Oxera provided economic expert advice to MasterCard in many of the merchant litigation cases. So Mr. Merrick's claim was rejected in the CAT on two specific grounds. Firstly, the tribunal found that Mr. Merrick's was not able to point to sufficient data for the pass-on methodology that was proposed by his experts. And secondly, the tribunal found that Mr. Merrick's approach of allocating losses between class members didn't account for individual losses that may have been suffered. So then, Mr. Merrick's appealed this decision. The Court of Appeal disagreed with the CAT on both of these grounds. The Court of Appeal said that the tribunal had set too high a bar for certification regarding data and methodology. They concluded that the existence of pass-on itself was a common issue and that the certification hearing is not a mini trial. Therefore, the experts do not need to provide all of the evidence at this stage. And secondly, the Court of Appeal determined that the certification stage is to decide whether claims are suitable for an aggregate award of damages and not to consider how to distribute the award between individuals. So after that, MasterCard challenged both of these issues at the Supreme Court hearing, which took place in May. Many of us here are waiting with bated breath for that judgment. One possible outcome is that the Supreme Court determines that the test the tribunal applied was too high, and therefore the CAT needs to revisit the case in light of a more lenient standard. Another possible outcome is that the Supreme Court agrees with the tribunal's original findings. For this reason, the Court of Appeal judgment might be seen as being claimant-friendly, but it's not the end of the story. We need to hear what the Supreme Court has to say.
Thank you for that great summary. So, Joe, let's turn to you. Since the decision of merits is generally viewed as a win for the plaintiff, would you provide your perspective on the opinion from the plaintiff's perspective?
So, good morning, everybody, again. It's nice to be with you. So I generally agree that it is favorable for plaintiffs. I think that, among other things, there's always a question about what the standards are going to be and what the level of proof is going to be required. What has happened in the United States, and we'll talk about this a little bit later, is that there is an increasingly higher evidentiary burden. That is something that U.S. class action lawyers have been handling now for a number of years. Of course, we have a different system where we are entitled to much more party-driven discovery from the outset of the litigation. But I guess what I would say generally is my impression is that Merrick's is a very is generally a favorable decision in a couple of ways from the perspective certainly of a U.S. Antitrust class action lawyer. One, I do think, and I think this is even evident in the most recent Supreme Court decision, is that the court is handling these issues with a fair amount of pragmatism. And by that, I mean that the courts are not going to require a level of proof which outstrips the data that's available. I think one of the things that's clear about Merrick's, where it's going, to me, is how important economic analysis is going to be. And that's certainly very similar to the experience in the United States. So much of class certification right now is about econometric and statistical modeling. And we have developed a number of techniques based on, I think, advancing methods of analysis to handle those problems. I also think one of the things that is also true is that there are more sophisticated analytical tools and more data available than ever before. And I think this all generally supports or encourages claimants or plaintiffs, from my perspective, in these cases. I guess the other thing I would say is that it's clear to me that one of the big issues, certainly in cartel cases, and this may not be of more general application, is the issue of pass-on. It is clear that that was one of the issues in the recent Supreme Court decision about what the state, the way a U.S. lawyer talks about this is to what extent is the pass-on defense available. The Supreme Court used very similar language to U.S. lawyers when they talked about whether the issue of pass-on can be used as a sword and as a shield. That is virtually identical to language from Hanover Shoe, which is the big Supreme Court case a number of years ago in the United States. So to me, I think where there is going to be some challenge in the future is how you deal with the pass-on issue and how you deal with that consistent with principles of pragmatism and in keeping with the more broad social importance of having group or class actions to prevent any competitive activity, to address those wrongs, and to improve the economy. So, Michael, maybe I'll just stop right there.
Okay. Thanks, Jim. And Gordon, could you provide your perspective from the defense perspective?
Certainly, thank you. As a threshold matter, I think I would agree that the opinion sets a lower threshold and lower standard for class certification than what we are seeing in the United States. I think what I want to focus on today is how I think this opinion departs from U.S. practice in 4 principal respects. First, when you look at the Court of Appeals opinion, it relies pretty significantly on its determination that the plaintiff's claim in the case on the merits, quote, had a real prospect of success. In other words, the court felt that because the plaintiffs had a good case on the merits, it followed that it was a strong case for class certification. This is actually very different from the U.S. practice. In the U.S., we have a federal statute called the Rules Enabling Act, which basically says that the standards of law, the substantive standards that are applicable to parties' claims, can't change as a result of a rule of civil procedure, and in this case, the Federal Rule of Civil Procedure 23. So that we have federal law that basically says you can't change the substantive standards just because the case is a class action. And for a long time, the U.S. Supreme Court has held that a court in deciding whether or not to certify the class can't look at the strength or weakness of the plaintiff's claims in making that decision. There was a lot of confusion for decades about how that should apply, but the Supreme Court about 10 years ago made very clear that the relevant inquiry with regard to merits evidence is not the strength or weakness of the plaintiff's claims, but rather the nature of the proof, and whether the nature of the proof that's necessary for the plaintiff to win, or the nature of the proof that the defendant would offer in defense, whether that proof is common to the class or individualized. So I think that's one very important distinction. That's clearly an issue that the Supreme Court in the merits case is going to have to determine. Second was the willingness of the Court of Appeal to endorse the top-down calculation of aggregate damages, even though that calculation didn't really purport to address the actual damages of any class member. And again, I think this is arguably at odds with U.S. practice in the Rules Enabling Act, which says you can't be changing the principles of law that are applicable to the elements or the proof as the plaintiff's claims. And again, I think this is an issue that will be an important issue for the Supreme Court in the merits case, whether the standards of proof as to fact of injury or the amount of damages can change because the case is a class action as opposed to litigated individually. Third, and I know that we're going to touch on this at greater length, and so I'm not going to belabor it, is the statement by the court that it was not going to conduct a mini trial. And although there is not an explicit requirement for mini trials in the US as part of class certification, as we're going to talk about in a bit, in practice, class certification determinations have become far more evidentiary with a much more developed, robust record beforehand. And then finally, I think, is the Court of Appeals endorsement and invitation to use litigation funding. There are obviously different economic barriers and opportunities available between the US and the UK. I think those are the four significant distinctions and takeaways I got from looking at the merits opinion.
Thanks, Gordon. And Kimela, from an economic perspective, what are some of the key differences that you see between practice in the US and what merits portends?
So the collective action regime in the UK is in its infancy compared to that in the US and some other jurisdictions. We're still only reading the tea leaves on exactly how the economics will work at the certification stage, let alone at the trial stage. So let's take stock of what we do know in the UK. Merrick's is not the only class certification hearing we've had. It's the second one. We've also had the scooters case, which was the first case in the CAT, and one in which we, Oxera, acted as the economic experts for the claimant. The scooters case stalled over issues concerning limitation periods, but it gave us valuable insights into how economic evidence can be used. So both the scooters and the Merrick's judgment cite the Canadian Supreme Court judgment from the Process versus Microsoft case in 2013. We know that the methodology must offer a realistic prospect of establishing loss. The methodology cannot be purely theoretical or hypothetical, but must be grounded in the facts of the case, and that there must be some evidence of the availability of the data. And that test should apply at the certification stage. So in the scooters case, which had a significantly smaller class than that in the Merrick's case, we were able to demonstrate a viable economic method as we had an overcharge model using a subset of sales data, which is effectively proof of concept. So the Merrick's case will give us some guidance as to how much economic evidence needs to be shown at the certification stage. But there's also lots of outstanding questions which relate to the economics test, which won't be addressed by the Merrick's test and will be addressed by future cases, such as those that are currently in the CAT.
Well, thank you for that. And so we've heard from both of our practitioner panelists about the notion of class certification being mini trials in the US and some perspective on the scope of that, the economic evidence from our economic expert. So Joe, let me turn this to you. I think it's fair to say that the challenges that Gordon and his colleagues on the defense side have raised to class certification over the years have led many courts to hold what are effectively mini trials on class certification in the US. Could you just very briefly give the audience some perspective on the evolution of certification in the US and where you see it relative to the UK?
Sure. So when I started doing class action work about 30 years ago, I think it's fair to say that the law in place with respect to Rule 23, our class action statute, was pretty much the same as it was at the time of the introduction of the class action rule as part of the Federal Rules of Civil Procedure in 1966. 1966 is when the modern Rule 23 was put into our civil rules. During that early period, the practice and indeed the requirement in some courts was that the class certification issue was a threshold issue in the case. It was required in many jurisdictions to address it as soon as one could. And it was done without the benefit of really any discovery, with just some basic analysis about the nature of the claims. The origins of the U.S. class action device, like in other places, involve predominantly antitrust and securities cases. And because of the nature of those claims, it was very easy to see and explain how that, for example, everybody who purchased from a cartel suffered the same type of economic injury, or if everybody purchased a security in a public market and that they were relied on misrepresentations by the company, that those were similar issues. So at that time, it was the practice, certainly in the direct purchaser cases, that in antitrust cases, that the defendants really frequently just agreed that the class would be certified, and there was really no fight about that. Even saying that out loud makes me sound like a geezer, right? That seems like a memory of a time far off in a fictional world. And perhaps that's to Gordon's credit. Gordon and his colleagues have made us work a lot harder and better and smarter. So thanks, Gordon. I appreciate that. But what has happened is that a couple of things. I think that there has been some attack on that idea and a requirement that there needs to be more proof about certain key issues, about whether one can prove impact or causation on a class-wide basis. There's a dispute in the United States about what the standard is, whether one has to come up with show the presence of a method for that's applicable to the class that shows that all or nearly all of the class members have been damaged, and then second, that there is a method for calculating damages on a group or class-wide basis. Those are the big issues in the United States right now. And I think through a combination of increased scrutiny on that, I think a more conservative judiciary, as well as the Supreme Court raising legal standards and courts of appeal overturning district court class certification, it's conspired to require at the trial court level more proof. And there's been kind of a ratcheting up kind of quality to the development. I think one key feature is that trial courts are relatively inexperienced. Now, remember, in the United States, we don't have specialized courts. We have courts of general jurisdiction. And so, when you file a case, you get randomly assigned to an Article 3 federal judge. And very few of those judges have much grounding in the things we're talking about, in economics or statistics or antitrust law. So there is a little bit of a learning curve, and I think particularly with the idea that there are courts of appeal or superior courts that are going to look down or after on the decision, there is a great incentive for the trial courts to develop a full record, to really understand the case. And I think all of that conspires to create a situation where increasingly the class certification proceedings have gone from where it was basically done by stipulation to it was a point where it was largely an argument among lawyers that might take 30 or 40 minutes to an all-day argument of lawyers to something that now looks a lot like a trial on the merits, with arguments by lawyers, testimony by witnesses who were involved in the event, by economists, and cross-examination. And so that's really been the key, I guess, development in the United States. So to turn that to the UK or Europe more generally, I think the general question is, to what extent are the courts going to feel like it is required to have the kind of evidentiary presentation that I think is becoming more common in the United States, or do it more generally based on more theoretical proof of what the claim is and how it's going to be handled. Again, one of the key differences is that in the United States, we have a discovery system where the parties are permitted to conduct and develop this factual record essentially from the beginning of the case. And so by by the time the class certification hearings happen, as I've described, there's been a very, very extensive discovery record developed. There, we've looked at millions of documents. We've taken the sworn testimony of dozens, if not hundreds, of witnesses. We've had testimony of it can be dozens of economists. And so I guess one question will be whether, when confronted by the issues that are no pun intended common, whether the UK tribunals or other tribunals are going to require that level of proof, given the absence of more extensive discovery. So I think those are key questions. Michael, I'll just stop right there.
Sure, and thanks, Joe. And we're going to talk a little bit more about discovery in a minute, and maybe we'll jump ahead to that. But I want to get perspectives. So Gordon, what Joe described with Merrick's kind of harkens back to the early, maybe nostalgic days of certification in the U.S. But what, as you analyzed the decision from a defense perspective, what benefits or challenges do you see in the evolving standards?
Thanks, Michael. And I agree with Joe in terms of the evolution of practice in the U.S. And I also agree that Merrick's, in many respects, parallels the early class certification practice in the U.S. I think what has happened in the U.S., the early cases in the U.S. were largely either antitrust cases or securities cases where the underlying conduct involved clearly was the same with respect to members of the class, and the arguments with regard to impact were, I think, probably the tightest. But we saw the evolution of all kinds of different class actions, product liability class actions, consumer protection class actions, other kinds of fraud class actions where the issues aren't nearly as clear as employment cases. And so what you ended up then seeing in the early 2010s is a trio of U.S. Supreme Court cases that basically said, you district judge need to do a so-called rigorous analysis of looking at the evidence, both from what the plaintiff would prove to try to establish the plaintiff's case and what the defendant could offer by way of defense, to determine not whether it's a good case or a bad case, but whether the nature of the proof that is important to the case actually is common to all members of the class, or whether the claims of the class members turn on individual facts. And so when Joe was talking about what's going on in these evidentiary hearings that have developed, it's really trying to understand and educate the court on what would be the nature of the proof in this case to see whether or not there are sufficient common issues, to see whether those common issues predominate, and to do that based on a robust record. One of the consequences of that for a defendant is the process of getting to the class certification hearing is much more expensive. As Joe noted, there's a lot more discovery. The expert workup is much more complete, and it's done at a later stage in the proceedings generally. And so the trade-off, I think, from the defense standpoint is it's often far more expensive to get to the class certification hearing today than it was when I first started doing this work 35 years ago. On balance, however, from a defense perspective, I think that's an important trade-off. The Federal Rules of Procedure says that a class certification can be revisited later. The Merrick's Court of Appeal opinion says the same thing. But in practice, in the U.S., very, very few cases are later decertified by a judge. There's enormous settlement pressure after the certification decision has been made. And in practice, very few judges go back and revisit the certification. So it's very important to get it right. And there are tools that a defendant can use to try to at least limit the expense so it's not boundless. But I do think, there certainly are trade-offs, but from my perspective, having the decision be a more informed decision based on the actual evidence is important from the defendant's perspective.
Thanks, Gordon. Kimela, how do the differences shared by the legal practitioners drive your approach as an economist to the collection and analysis of economic data? And could you share some of the key challenges that you see for both sides from your unique perspective?
As we just heard from Joseph and Gordon, the threshold for certification may shift over time as more novel and complex issues arise. And the questions that economists will be asked to consider at the time of certification may also differ. So the current roster of claims in the UK is dominated by follow-on actions, which rely on competition authority decisions. But as the regime develops, we're more likely to see more standalone actions, which don't rely on a competition authority decision. And in this case, might require a higher standard of economic evidence and more detailed analysis to show liability, which is then a higher burden for claimants. I think from the economics perspective, wherever the bar is set, on the whole, there's a huge amount of economic analysis that can be done using aggregate data, web-based data that's been scraped, public domain data. So the economic tools that are available can be adapted to suit wherever the threshold for certification lies.
Thanks for that. And I want to talk a bit more about discovery, but before I do that, I think that there's an important aspect that Gordon touched on briefly that represents a key distinction between the U.S. system and what we see in the UK and Canada and elsewhere, which is the proverbial English rule. So let me just throw this out to our panelists generally. What role, if any, do you think the English rule or the loser pays system plays in the different approaches the council might take to similar or identical claims in the US or the UK or Canada in light of merits, with these very different standards, how, one being more searching than the other, one jurisdiction allowing a lot more discovery than the other. Let me just throw that out to you generally, see what's offered.
So let me grab it first, because this is about bringing cases as opposed to defending cases, as I understand the question. So it's appropriate, I think, that I take a first swing at it. So look, this is a key question and a key distinction, and it has to do with the economics, at least from my perspective as a lawyer in the United States who does predominantly contingent fee class action litigation. This difference, this distinction is key, because I think from the perspective of someone who owns and runs a class action business, one has to be very careful about case selection and the investment and risks associated with particular types of cases. In the United States, when we are when Michael's firm or my firm are trying to decide on whether to take a case, we don't really think very much, candidly, about what happens if we lose with respect to costs or adverse findings against us. We are comfortable with the economic model where we invest our time and our money in cases. Litigation funding is becoming more prominent in the United States, but to date it has not been a big factor in doing what my firm does or Michael's firms have been doing historically. So we think a lot about case selection, but our risks are much smaller. Now, in a system where if there's a loser pays situation, the premium on case selection is really, really important. And I'll talk about insurance in a moment. I think the prospect that one would bring a case and then be responsible for the costs of the other side means, among other things, that you have to be, as counsel, very comparatively more confident about your ability to succeed in the case. And so really what that means, I think, is it drives the case selection in large measure towards cases like antitrust cases or securities cases, particularly if there's a finding by, the competition authority, which has the effect of a preclusive effect with respect to the merits. Now, that puts the lawyers in a much more advanced position with respect to the merits, and substantially reduces the likelihood of adverse results. So I think that the kind of loser pay rule, among other things, means that it is comparatively more likely that the antitrust cases and security cases will be where the action is, where most of the cases are going to be brought. Having said that, I think other cases will be brought, but I think what that really means is that the importance of adverse event insurance or litigation funding becomes that much more important, so that risk can be shifted and shared away from the lawyers. So that's certainly my perspective.
Kimela,
I agree. I would agree with that. But the only thing I would add is I think because of that reality, I think that is why the Court of Appeal said explicitly that the UK class action regime was, quote, obviously intended to facilitate a means of redress which could attract and be facilitated by litigation funding. Litigation funding doesn't answer all the concerns with regard to loser pay, but I think because of the real difference between the barriers in the US and the barriers in the UK, I think that's why you saw what you saw in the Court of Appeal.
Since we've touched on a bit of discovery, interlacing through these questions, I wanted, just with the last 2 minutes, if I could just kick a question to Kimela that I think intersects with a lot of the work that she does and the differences between the two regimes and where they're going, as well as discovery. And that's just with respect to privacy. I think it's fair to say that the attitudes toward privacy can be very different in the US and the UK. And I wonder, Kimela, could you just speak to a moment on the obstacles or opportunities that you may be seeing in the wake of merits as compared with the US, given how the US and UK approach the privacy of potential class members' data and personal information?
So I guess perpetuating a stereotype, as an economist, I love data. Give us more data. We want more disaggregated data and more detailed data all the time. But that being said, we can still go a very long way using highly aggregated data, highly anonymized data, public domain data. There's also data that can be collected from class members with their consent, and that can all be used. So I think there's lots that economists that can do, working within any set of rules of protection around personal information. So I think while the cultural differences might be different there, I think there is lots for economists to be able to offer in that space.
Hi guys, so we got 1 more minute to wrap it up. Kimela and her team and Oxera have kindly accepted to answer questions also during the break at their booth. So if there are any other questions from attendees, please feel free to reach out to Kimela and her team directly. But I found it quite productive as a first session, and hope everything goes as smoothly as this one moving forward.
Well, thank you, everybody. Thanks for the opportunity.
Please.
Thank you. Enjoy the conference. I'm happy to be
Make the most of the networking. I know it's not the same as a live event. It's a numbers game. Let's have as many contacts as possible that we can then have a drink with when we're allowed to.
It's very early in California.
Absolutely fine to have early as well. Take care.
Thanks, everybody.
All right. Thank you, guys.
Thank you.
Bye.
Bye, everyone.